P.elect LAWASIA to share his thoughts. The floor is yours.
Thank you, Mr. Uday, for the kind words of introduction. I would also like to thank Mr. Prashant Kumar, President of the Bar Association of India, and the BAI for the opportunity to share the stage with my esteemed colleagues on this session. I think, to be fair to Mr. Shyam Divan, he did not ask me to present this. And that's the problem with volunteering, right? Something you never knew what it was about actually when you first said yes. But on the topic of today's discussion, the protection of human rights extends beyond treaties which are legally binding and agreements, principles, and guidelines which are not legally binding. Soft law in some cases are the precursor to the development of hard law norms. Many international human rights treaties have been preceded by soft laws, which covers declarations on the same topic. That said, enforcement of breaches of human rights violations continue to pose challenges within the domestic front as well as the international community. Enforcing human rights treaties is challenging due to the state sovereignty, lack of political will, weak international enforcement mechanisms, but effectiveness may be enhanced by national implementation mechanisms, oversight by international treaty bodies and the courts, individual complaints mechanisms, and the indirect influence of monitoring and reporting. While direct sanctions are rare, pressures from reports, public opinion, and the growing body of human rights law can guide states towards compliance and improved practices. The Universal Declaration of Human Rights of 10th December 1948 is widely recognized as having inspired and paved the way for the adoption of human rights treaties, applied today on a permanent basis at global and regional levels. Building on the achievements of the UDHR, the International Covenant of Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights entered into force in 1976. These two covenants have developed most of the rights already enshrined in the UDHR, making them effectively binding on states that have ratified them. They set forth everyday rights such as the right to life, equality before the law, the rights to justice and fair trial, freedom of expression, the rights to work, social security, health, and education. Some of the treaties which have come out of the UDHR, for example, are the Convention on the Rights of the Child, Convention on the Rights of Persons with Disabilities, Convention on the Prevention and Punishment of the Crimes of Genocide, Convention on the Elimination of All Forms of Discrimination against Women. The challenges that have posed covers some of the following. Where the lack of political will, for example, is concerned, states may prioritize national interests, such as economic or security concerns, over human rights obligations. Weak enforcement power is another challenge, and international bodies often lack direct enforcement powers, making their influence actually contrary, more indirect. International law relies heavily on the consent and cooperation of states, which can limit the authority of international bodies. So one can see the tension that is developing or has developed and will continue to develop. May I now turn to soft law and the UN Guiding Principles on Business and Human Rights of June 2011. These guiding principles are grounded on three pillars: the state's existing obligations to respect, protect, and fulfill human rights and fundamental freedoms, i.e., the government to protect human rights. 2, the role of business enterprise as specialized organs of society performing specialized functions required to comply with all applicable laws and to respect human rights, which means companies are now also to respect human rights. And the third pillar, the need for rights and obligations to be matched to appropriate and effective remedies when breached, which means victims of corporate abuses to have access to effective remedies in law. Guiding Principle 25 of the UN Guiding Principles on Business and Human Rights states, as part of their duty to protect against business-related human rights abuse, states must take appropriate steps to ensure through judicial, administrative, legislative, or other appropriate means that when such abuses occur within their territory and/or jurisdiction, those affected have access to effective remedy. And Guiding Principle number 26 provides that states should take appropriate steps to ensure the effectiveness of domestic judicial mechanisms when addressing business-related human rights abuses, including considering ways to reduce legal, practical, and other relevant barriers that could lead to a denial of access to remedy. An article by Juan Jose Alvarez Rubio and Katerina Yanibas have noted that such barriers may include the lack of jurisdiction by the courts of a particular state, questions of which law is to be applied, absence of duties of care on the parent company, availability of legal funding and representation, and many others. Overcoming these barriers require states to conduct an assessment that will provide it with a clear view of which barriers are problematic in their own legal systems and what should be done to have them eliminated. The European Coalition of Corporate Justice has noted that the EU lacks coherent and comprehensive policy framework to ensure businesses respect human rights. Victims of abuses have to wait years for justice, but to no avail. Corporations can wreak environmental and climate change without serious repercussions, and we do continue to see that in today. Not all EU states have their own action plans. Almost half are lagging behind with no regulation, instead of relying on voluntary action by businesses, hence no oversight. Victims must have recourse to companies which should be held accountable. What then needs to be done to try and overcome these challenges, and what is the way forward? The global reach of transnational businesses have significantly increased over the past 30 years as a result of liberalization of international trade and investment. Yet the conditions under which these businesses may be held liable for human rights abuses have not aligned with this evolution. States have in general failed to fulfill their duty to protect human rights by ensuring that victims have access to effective remedies, including judicial remedies, particularly for human rights abuses that occur abroad, extraterritorially, at the hands of businesses. This resulting lack of access to judicial remedies provided by home states for human rights abuses by businesses, in particular, those abuses that occur extraterritorially, has a considerable impact on the effective exercise of human rights. In host countries, host in inverted commas, where corporate abuse often occurs, victims can face barriers associated with weak rule of law and corruption. The inability to enforce court decisions is equally significant. Even when justice is served, the problem is that there is no way of enforcement where corporate culprits have their assets. When attempting to bring cases against companies before the home courts for harms committed abroad, the victims also face unique procedural and substantive barriers which are often insurmountable. Just to give an example, you may remember the Royal Dutch Shell case, in which lasted almost 13 years and demonstrates how difficult it is for victims of harm to obtain justice. A key barrier to that case was the corporate veil, a corporate shield against liability for human rights abuses by a subsidiary company. In court, the oil giant had argued that it was not responsible for the oil spills, which happened in Nigeria, which affected 40,000 Nigerians, and other violations committed by the Nigerian subsidiary. It is exceptionally difficult for the plaintiffs and their lawyers to disprove, as it required significant disclosure from parent and subsidiary companies, and such information, as we are all aware, are not readily divulged. This exemplifies how parent companies use their subsidiaries as a shield against liability for human rights abuses occurring in their corporate group. In around April of 2020, Didier Reynders, the European Commissioner for Justice, had announced that he would propose some human rights and environmental rules for companies. Now, to prevent further tragedies, there ought to be administrative, civil, and criminal liability for corporations with serious penalties for those failing to comply. This would not only incentivize companies to do better, but is also the only way to provide grieving, traumatized, and injured workers and their families a much-needed path to justice and compensation when companies fail to prevent abuses. Digressions from hard law would presumably generate more shame, as the company would be a breaker of international laws. Digression from soft law norms by companies attracts attention from civil society and media, and therefore a degree of shame and brand damage. In conclusion, there's much work to be done, both at the state level and in the international arena. The issues are not confined to this part of the world, but is international. Perhaps, if I may respectfully suggest, that the following may provide a starting point for enforcement, which is ultimately what this is all about. Legal precedent and the body of decisions and interpretations from treaty bodies and the courts will help to clarify and apply international norms to real-world situations. On the domestic front and implementation, when treaties are incorporated into domestic law, their provisions become directly enforceable in the national courts. What about international pressure? Monitoring, reporting, and the threat of international condemnation can influence state behavior and encourage compliance. Public scrutiny. Reports from treaty bodies and NGOs, along with media coverage, can raise public awareness and subtle pressure on governments. It is with those thoughts that I leave you for this morning's session. It certainly raises more questions than answers. And on behalf of my panel, I'm sure they agree with me, the answers really rest on political will of the governments. So please direct your questions to the right people. Thank you.
Fantastic. And in the conclusion,